Good Monday morning, afternoon, evening, depending upon where you are in the city. Welcome to From the Halls of Justice. We have two spectacular people with us today. First of all, there's my co-host, Alexandra Rachel Lavinsky. Her offices are here in West Hollywood, and she's a spectacular rising star and super lawyer. And she's going to help me interview the fabulous, honorable Commissioner Keith Clemens of Beverly Hills, but he came down to West Hollywood just for us. So I'm going to tell you a little bit about Commissioner Clemens. He is a retired commissioner of the Los Angeles Superior Court. He's been judging family law cases for the past 24 years. He's been on the bench, and he's on the bench as a private judge now. Commissioner Clemens graduated from UC Berkeley, go Bears, did graduate work in economics and then at Harvard University, and then went to law school at UCLA School of Law, go Bruins.
Go Bruins.
And now he practices in Los Angeles. It's been 17 years. It was 17 years before he was elected by the judges to go on to the Los Angeles Superior Court as a commissioner in 1991. On the bench, except for a few months in criminal law, and he handled family law cases. Since he's left the bench, he is now full-time as a family law neutral. So, thank you for joining us on From the Halls of Justice.
I'm really pleased to be here.
Thank you very much. Now, Alexandra, you are my high-powered attorney here, so I'm going to let you take the lead in interviewing our commissioner, and I'm going to join in and jump in whenever you let me. And tell us, go ahead and you take the lead.
Okay. Thank you for being here. We're so honored and glad to have you. First of all, what kind of cases are family law cases?
In Los Angeles County, the family law courts, the family law departments, handle dissolution of marriage cases, what we call divorce. They handle the dissolution or termination of domestic partnerships. They handle paternity cases. They handle domestic violence cases, and they handle nullity cases, nullity also called annulment, which is sort of the opposite of divorce. In divorce, parties come in and say, we're married, at least one of us wants to terminate the marital relationship and become unmarried. In a nullity case, it's the opposite. You come in and say, I don't think I was ever legally married for a variety of reasons, and I want you, the court, to issue an order that says that I was never married and there was no marriage, and the whole idea of the marriage, it was a nullity.
And now that you have retired from the bench, how is it that you work as a judge, and what do you do as a judge?
That's a very good question. California allows for private judges. California, under the state constitution, will let people who have civil cases, certain probate cases, family law cases, if all the parties and all the lawyers agree, they can have actually any member of the state bar can be the private judge so long as the supervising judge of the Superior Court approves of that selection. In practice, most of the private judges are retired judicial officers, but sometimes lawyers who were never on the bench will become the private judge for a particular case. Parties simply sign that written stipulation. It goes in, the presiding judge decides yes or no. Once you're appointed as a private judge, you have the same powers, with very narrow exceptions, as a judge who is sitting on the bench. The differences are, for one, you will never do the case in the courthouse. They'll all end up being done in attorney conference rooms for the most part. And there are a few things that a private judge can't do, like order files to be sealed. But for the most part, we have the same powers as a sitting judge, and, at least as importantly, the parties themselves have exactly the same appeal rights as they have for orders and judgments that are made by a sitting judge. Everybody can take their case, if they think it's warranted, to the Court of Appeal if they think serious error has been committed.
And why would I want to come to you either as an attorney of a family law matter or as a party without a lawyer?
Well, for one, it lets everybody decide who their judge will be, because the only way somebody becomes a private judge is if everybody agrees that'll be our judge for our case.
Oh, that's wonderful.
For two, they might do it because in a lot of cases it's going to be more economic and to use a private judge, and I'll explain why in a minute. Okay. And for three, it may be faster. Why is it more economic? Well, it's actually not going to be more economic if you are representing yourself without an attorney, because when you get a private judge, you're going to be paying the private judge, and private judges charge the same way attorneys do. But if you have an attorney representing you, you're paying your attorneys, and because the case is handled more efficiently, whatever you're paying the private judge will pay a whole lot less to your attorney. Why? Well, because when you go down to the courthouse on any given day, whatever family law court you've been assigned to, there'll be 10, 15, 20 cases on calendar, and you may not get all that much hearing time, and your case may not be called, and you're sitting around the courthouse for sometimes many hours, sometimes well into the afternoon before your case gets called.
And you're being billed for that time.
And you're being billed for that time. When you're with a private judge, that's the only thing that's happening that day, and there's no wasted time, there's no downtime. In addition, everybody can start when everybody agrees they'll start. You don't have to take long lunches. In the courthouse, the courtrooms are all shut between 12 noon and 1:30 p.m. If you're doing it privately, if you want to take a short lunch, you can do it. Just keep right on going. And there's no rule that says you have to stop at 4:30 as you do in the courthouse. If you need to go late, we can go late. In addition, an awful lot of matters where you have a private judge simply get decided as a result of telephone conferences. If there's a problem, lawyers will simply pick up the phone and call the judge and the other lawyer, and we'll get on the phone and we'll solve problems. If we have to do things the hard way, if we have to do things formally, we can do that. And I certainly never punish anybody for saying, let's do it formally. I don't want to do it this casually. Mm-hmm. Everybody is entitled to complete due process. But there are a lot of problems that can be solved very efficiently, with telephone conferences, and there's no reason to have to go through all the formality that you're required to go through for minor things. But you'll have to go through all that formality in the courthouse because it's the only way the system will work. So those are all good reasons why private judging actually can be more economic for parties. Having said that, there is one thing that, as a citizen, I'm not so happy about. I'd really like to have a system where we didn't have private judges. But that would require that you build a whole lot more courthouses, mm-hmm. and you hire a whole lot more judges and all the staff to support them. And we all know that the state doesn't have that kind of money. In fact, it's gone the other way. Because of the financial problems the state has faced, an awful lot of courthouses and courtrooms have been closed. And it's just that much harder to get all the cases that exist, decided through the court.
Now, for me, just off the top of your head, what would be a small matter of a decision that you would be hearing and you could hear it telephonically versus perhaps hearing a case and they're present in front of you? Because sometimes people say that you can tell a lot about a person through their body language and what's going on. I mean, is there a big difference?
Well, a lot of the problems are as much with the lawyers as with the parties. For example, there'll be discovery disputes. Mm-hmm. Pick up the phone, we call, we talk about it, we solve the problem. There's no reason for everybody most of the time to actually have to do all of the formal paperwork and generate an ex parte application, which involves a lot of lawyer time, when we could just discuss it. Some of it is just mechanical. We need a continuance. Some of it are small custody disputes. Somebody says, that they would like to pick the kid up early, and the other parent isn't willing to do it, and maybe that's the kind of thing that it's useful to have the court get involved, and it can be done much more efficiently that way. So there are lots of small things, but occasionally there are big things. And by the way, if we need to, when we have a telephone conference, if they want a court reporter, we just add a court reporter to the call, and the court reporter takes everything down in the telephone conference, just as he or she would in a courtroom or a conference room.
Now, can I have a jury trial in a family law case?
Not in California, and not in 48 out of our 50 states.
Oh my goodness.
There are 2 states that will actually allow parties to have jury trials in family law. And I must say, the idea of having a jury decide who should be the primary parent of children, that's kind of a little scary thought. But that's historically, divorce was not something where juries were a right of parties. It wasn't true in England, and therefore it's not true here. And so in California, no juries.
No. Okay, and are you going to name the 2 states?
If you like, it's Georgia and Texas.
Georgia and Texas. Now, one of those states, is it Texas, where if it's infidelity, and do they still get to shoot the cheating party? I mean, really, I saw that on TV.
I haven't been in Texas in decades.
Okay.
I don't know.
Oh my God. Now, are most family law cases settled, or are they would they go to trial?
Most family law cases are settled, and in fact, most cases of every kind are settled, because frankly, the court system is not equipped to handle the large volume of cases that are filed every year. And if we can't settle 97, 98% of the cases, the whole court system crashes and burns. So there's a lot of things that the court does to persuade people that they ought to settle. Right from the start, and then right up till you get close to trial.
Okay.
So most cases do settle, and frankly, most cases should settle.
Right.
By the time you're ready for trial, the parties pretty much know what the evidence is going to be. Either the lawyers or a judge can say what the likely outcome on a lot of disputes, not every one of them, but a lot of disputes will be if the evidence is as described. And if you already know what the likely outcome is, then why go to all the trouble and expense of going all the way through trial? Now, people will do that. Sometimes they just won't settle. And other times they go through trial because there are issues where it's really not clear what the answer is going to be. And the judge really does need to listen to the witnesses and decide, which side is more credible. And, those trials make all the sense in the world.
Can I ask you a loaded question?
Depends what it's loaded with.
Okay. So what kind of documents would help me present my case? What kind of documents or evidence are you looking for in discovery to help? To help me win. I want to win.
Well, it depends what the issues are. If there are financial issues...
He's hiding money.
Yeah.
I've been married to him for 20 years, and he left me. And when he left, now we had a good life. However, when he left, all of a sudden, he has nothing, and it all belongs to his brother, and I know he's lying.
Well, whatever documents you can find to help you show that it's not very credible, are going to be useful. I mean, if all I have are 2 people, and one says it's black, the other says it's white, who knows which party is telling the truth, but the party who has a piece of paper that says, yes, it was black, that's really helpful. The example you gave, for example, there may be all sorts of documents over the years that show that the property really was in his name, or that he had the income or made transactions that make it indeed look like it's his property and not his brother's property. Those documents are helpful, but they're, family law actually covers a wide variety of issues and problems, and the kinds of documents that may be relevant include all kinds of documents.
Well, what should I be looking for? Because I loved him. I trusted him. I didn't think about anything. I never paid a bill or opened the mail. I just went to the bank.
You're asking the wrong person.
Oh,
you need to ask. You need to ask Ellie. This is exactly the kind of thing that a lawyer is really helpful for. The lawyer is a person who knows the kinds of things that'll turn into good evidence that'll be useful to help you prevail and get a just result.
And that will help the judge, because if parties go to the judge and they don't have the proper documentation, it can be very frustrating for the parties and for the judge, because the parties give up hope because they don't understand that the judge can only help once the judge has the information that the judge needs.
Right. We have an adversarial system. The judge is sitting there listening to the evidence that's being presented. The judge is not an investigator who goes out and does that investigation, for you or for any other party. Now, in Europe, they have a different system, and the judges really are investigators, at least in some countries, but not here. Or, as I sometimes say, they give me a black robe, not a black mask and a silver bullet. And actually, they don't even give you the black robe. You have to buy your own.
Oh my God!
You do.
Wow.
It's okay. It's a pleasure to have spent that money.
And is there a judicial law that requires that the robe come off?
And there is absolutely a rule that requires judges to wear the robes on the bench.
Oh my.
This is the black robe. You cannot say, I don't really want to wear it. You're not supposed to come out in a suit or anything else. You really are there is a court rule that says wear the black robe.
But I've never seen a judge not take his robe or her robe off in chambers.
Oh yeah, it's only on the bench that you have to have the black robe on. When you go back into chambers, which means the judge's office, there's no reason that you have to be wearing the black robe.
And when somebody or two people come to the offices to do a mediation or an arbitration, what happens? Many clients are very afraid because they've never been there before.
Sure.
So can you describe what happens when we get to your office, and do you divide us up? Do you keep us together?
The answer is all of the above. Most of the time when I'm doing mediations, I do separate the parties. There are times that I think it's useful to bring everybody into one room, and I'll do that. Otherwise, I just go back and forth like Henry Kissinger.
Wow. So I never have to be afraid that if I don't want to be in the same room,
Absolutely. And if somebody says, look, I don't want to be in the same room as my ex or soon-to-be ex, I will completely honor that. I'm very protective of people in this process.
That's awesome. So how do judges and commissioners help parties get the family law cases settled?
Well, there's a whole bunch of things that judges and commissioners can do. Some of them, at the very end, before you get to trial, you are going to be required to go through a mandatory settlement conference. That's why they call it mandatory.
All right.
And in a mandatory settlement conference, the judge who will have read all the briefs that explain the case, and everybody will have exchanged all the exhibits, the judge will know a lot about the case and will talk to the parties about what is likely to happen and why the case ought to be settled, and why they would simply be wasting time and money or taking unreasonable risk going forward with a trial. And an awful lot of cases do get settled at that point, but a lot of cases get settled earlier. And sometimes it's because the judge has had a discussion with the parties and the lawyers, or at least with the lawyers, and said, look, if the evidence is this, here's what the law is, here's what's going to happen. That's really helpful.
Very helpful.
It's very helpful. In addition, the court forces every party who has a custody dispute to go to conciliation court, which is not a court but a mediation service. And in an awful lot of cases, the parties are able to work out a parenting plan for their children in conciliation court. Again, that just saves time. And there are volunteer attorneys. Family law attorneys as a group are terrifically valuable and contribute thousands of hours a year to work as unpaid volunteers to settle cases. And that's really helpful. There's a system, the self-help center in the courthouse can be helpful. And parties themselves, of course, have an incentive to get the case over with. Not every party will behave that way, but most parties ultimately decide they need to become businesslike, because at the end of the day, this is a no-fault state. And if anybody who thinks he or she is going to get vindication in a family law trial, they won't. It took me years to appreciate just how much no fault permeates the entire system.
Now, what are the advantages and disadvantages of doing my case privately, or anybody's case privately?
Well, the advantages, as I've explained, is it can be more. It can, if you have a lawyer, it is almost certainly going to be more economic to do it privately.
Faster?
And it can certainly be faster. It's just a question of how fast everybody's ready to go to trial if it gets that far. Okay. Understand, in any case, whether you're in the courthouse or you've gone private, you can always settle at any time. There's no rule that says you have to take it all the way to the bitter end.
Okay. I was going to ask, so let's say, would you say that I could wrap my case up in 6 months versus maybe a year and a half or 2?
Well, there are plenty of cases in which parties actually never come to the court. They work out their settlement almost as soon as they start talking about the divorce. Now, legally, they're not going to get a judgment of divorce until there's been 6 months between the time that they file their petition and serve it and when we can legally grant the divorce. But their agreement can already be done 5 months earlier. Settlement, I mean, look, settlement stops the whole process, and it does take you to a place of finality.
Do you do bifurcations?
Yes, there are times that their parties will want to bifurcate the issue of marital status from all the other issues, meaning somebody wants to get divorced
very
now,
fast, yeah.
even before you get all the other property and support issues decided. And that can happen, but I will tell you there are some real downsides to doing that, because the court will impose conditions on the bifurcation, which makes the party who wants the bifurcation suddenly assumes all kinds of financial responsibilities.
Wow.
That wouldn't happen as long as they were still married. Well, for one, if the person who wants the bifurcation is the spouse who provides the health insurance through his or her employment, once the parties are legally divorced, that spouse is no longer going to get health benefits, meaning that spouse needs new insurance, and that's going to cost money. And well, now thanks to the Affordable Care Act, at least they can get the insurance. In the old days, it would be a problem if anybody had pre-existing conditions. But so whether it's insurance or numbers of other things, there will be conditions if you want to terminate status early. People will want to do it. Emotionally, some people just need to get it the marriage undone. Some people, of course, are hot to go off and get married to the new boyfriend or girlfriend. And some people just feel, for religious reasons, until they're legally divorced, they can't move on with their lives. So I understand it, but there may be costs to it. We also sometimes bifurcate other issues because if we can get one issue resolved early, it may make the rest of the case a lot easier to decide.
That's a good idea.
Yeah, so
that's a very good idea.
We can do that.
What kind of issue, for example, might one want to bifurcate or separate because it would help the rest of the case settle?
Okay, data separation is a good example. Under California law, once the parties have separated, and by separated I mean somebody has really said, hey, it's really over and I want a divorce, and then thereafter conducts themselves consistently with that, that terminates the continued creation of community property. Once you're separated, your earnings and the other spouse's earnings after that date are the separate property of whoever's doing the work. They're not community property. And in some cases, the date of separation, there'll be very little dispute. But I had one case where there was a 13-year difference between one party's data separation and the other party's data separation. And there were millions of dollars at stake on that. So that we bifurcated that issue, so we'll try the data separation question first. And once that gets decided, then we can figure out the rest of it. And it just makes for a faster and less costly case for the parties, instead of having to prepare evidence to show what happens at two different dates of separation. Figure out the right date of separation first, and then you can just spend all your time concentrating on figuring out the data for that date of separation.
Well, so this might be a question for Alexandra. Then we're back to, so for the date of separation, is this going to be the date that if we're still living in the same house, is this the date that you actually moved out of the bedroom? And what if we still visit each other, but we're still in the same house?
It's the date that one party told the other that the marriage was over or the relationship was over and took an act in furtherance of that marriage being over, moved out of the house, moved out of the bedroom.
Yes, you have to be consistent about not acting as if you're still married. It can be a problem. I mean, and the sad thing about that particular law is the kind of civilized behavior that you would hope people would have works against somebody who wants to think that he or she is separated. Just keep doing all the things that you would normally do, even if you're separated or divorced. If you've got kids, you're going to do things together. Well, that may not look like you're really separated. That's a terrible thing about that.
Commissioner, you are absolutely fabulous. And I want to thank you for being here on From the Halls of Justice.
Well, I've enjoyed this very much, and I thank you so much for inviting me.
Well, I hope you come back again.
I would be happy
Alexandra,
to.
thank you for being here.
Thank you.
And between all the education that we're getting here, this is worth thousands and thousands and thousands of dollars. So for the community, we honor you and we thank you for your time. That's just absolutely amazing.
My pleasure.
Thank you, Your Honor.
Thank you for joining us on From the Halls of Justice. Tune in next week, and you'll never know who might be sitting in our studio with us. Come back again.